Dear ladies and gentlemen, honorable justices, distinguished colleagues, first and foremost, let me express my greatest pleasure and sincere gratitude for having me as a speaker at this international conference among so many great scholars and professionals today. It is truly a special honor for me. I'm thrilled to bits to share my conference paper with you on the triangle of the crime of aggression, the International Criminal Court, and the United Nations Security Council. At the same time, as the last speaker of this afternoon, I can promise nothing but to be brief, concise, and mindful when it comes to the time limit of my presentation. So I had better start right now. Even though jus contra bellum is a well-established element of the set of imperative norms of international public law, having academic discussions on war and aggression is, unfortunately, not an outdated fashion even in the 21st century. Just take a quick look at this map of the world in 2023 and no more comments are needed. Despite the unambiguous prohibition of the illegal use of force, wars are going on even at this moment. International criminal law, sometimes moderate but still a promising tool of the rule of law to combat against wars and to bring the authors of war to justice. But thanks to its heavily politicized character, the issue of aggression has always been sensitive. We all have learned from the Agatha Christie stories that there is no murder without a corpse. And this analogy can be applicable to aggression as well. There is no crime of aggression without the state act of aggression. Namely, there is no crime without the condemnation of a high-ranking political or military leader and of the whole state. Therefore, not surprisingly, the definition of aggression, that is, whether or not to include this crime in the founding treaty of the very first permanent International Criminal Court, and if so, how to do it, was one of the most heated debates at the 1998 diplomatic conference that led to the adoption of the Rome Statute. Drafting states simply could not come to an agreement on a comprehensive definition of the crime of aggression. Some wanted to adopt a narrower approach covering only war of aggression, while others were on the side of a broader concept covering any act of aggression in accordance with the definition of the resolution of the General Assembly 3314. Moreover, the issue of whether the ICC should only exercise jurisdiction over the crime of aggression when the Security Council has already determined the existence of an act of aggression committed by a state against another was even more difficult. Thus, a final compromise had been reached as the crime of aggression was included in the enumeration of crimes under the jurisdiction of the ICC, but the definition itself and the detailed preconditions of the exercise of jurisdiction, especially the aspects relating the role of the Security Council, were postponed for repeated consideration by the first review conference of the Rome Statute. It is without a shadow of a doubt that an event of historic significance took place at this review conference in Kampala in 2010, when the long-awaited definition of the crime of aggression was finally adopted. it is important to highlight at this point that even though the Nuremberg Charter defined crimes against peace, and even though Article 2, paragraph 4 of the UN Charter clearly prohibits the threat or use of force, neither of them has provided on the definition of aggression. Following decades of negotiations, it was an enormous success when the United Nations General Assembly adopted the definition of the act of aggression in its already mentioned resolution in 1974. However, this resolution has covered acts of states, implying, of course, state responsibility under general international law, not acts of individuals, implying criminal responsibility. Consequently, the definition of the crime was still missing. As I have already indicated, it was indeed 36 years later at the Kampala Review Conference when the definition of the crime of aggression was born. The resolution adopted by the Assembly of States Parties amended the Rome Statute to include, among others, a new Article 8 bis comprising a definition of the crime of aggression and additional new Article 15 bis and 15 ter containing complex provisions on the conditions of the exercise jurisdiction over this crime. Noteworthy, though, this compromise included a clause that prevented the ICC from exercising jurisdiction over the crime of aggression immediately. Instead, the Assembly of States Parties had to take a further one-time decision to activate the ICC's jurisdiction no earlier than 2017, and the ICC could not exercise its jurisdiction until a year of the 13th ratification, which occurred in 2016. After the Kampala amendments had reached the necessary number of ratifications, the Assembly of States Parties enabled the ICC by consensus on its 15th session in 2017 to exercise jurisdiction effectively over the crime of aggression. The ICC's jurisdiction has been alive since 2018. This marks the first time when the international community has had a permanent international court with the authority to hold individuals accountable for their decisions to commit aggression, the most serious forms of the illegal use of force. The activation of the ICC's jurisdiction over the crime of aggression has actually two-folded results. On the one hand, it completes the Rome Statute as it was originally meant to be. On the other hand, it reinforces the prohibition of the illegal use of force under the UN Charter by helping to deter aggressive war-making of states. As for the Kampala amendments, Article 8 bis, paragraph 1, provides on the substantive definition of the crime of aggression, and under this provision, 3 criteria are to be met to commit the crime. First, unlike the other international crimes, genocide, crimes against humanity, and war crimes, aggression is by all means a leadership crime. That is, the perpetrator must be a political or military leader. Second, it must be proved by the ICC that the perpetrator was involved in the planning, preparation, initiation, or execution of such a state act of aggression. Third, such a state act must comply with the definition of the act of aggression under General Assembly Resolution 3314. At the same time, the state act must, by its character, gravity, and scale, constitute a manifest violation of the UN Charter. These elements imply that only the most serious forms, the peak of the iceberg, of illegal use of force between states fall under the jurisdiction of the court. If you take a glimpse on this slide, based on the text of Article 8 bis paragraph 2, it is as clear as day that it reiterates the elements of the state of act of aggression of the General Assembly Resolution. However, relying on the principle of legality, the Rome Statute required this list to be an exhausting one that is interpreted restrictively, with no other additional options for the Security Council or the ICC's pretrial division to qualify state acts as the act of aggression. As for the Security Council, it plays a key role in responding to state acts of aggression, and Article 15 bis and Article 15 ter of the Rome Statute, when providing the procedural steps of exercising jurisdiction over the crime of aggression, takes into account this key role and preserve the primary function of the Security Council in determining a state act of aggression. When doing so, the Campbell Amendments grant the ICC the same degree of judicial independence as already existed regarding genocide, war crimes, and crimes against humanity. Nonetheless, when it comes to the crime of aggression, the Security Council and the ICC may interact in several ways. First, the Security Council may refer a situation to the ICC when empowers the court to investigate the crime of aggression. The Security Council's powers under Chapter 7 of the UN Charter are the legal basis upon which the ICC can investigate such crimes without any prior consent given by the states concerned. Second, the Security Council may also suspend an investigation into a crime of aggression under Article 16 for a period of 1 year. Additionally, when an investigation is initiated by the ICC prosecutor on his own motion, or when a situation is referred by a state party before the court, the prosecutor must inform the Security Council about the investigation and give the Security Council 6 months to determine that an act of aggression has occurred. If the Security Council makes such a determination, the prosecutor may then proceed with the investigation regarding a crime of aggression in the same manner as regarding the other international court crimes. But if the Security Council makes no such determination within 6 months, the prosecutor may only proceed if so authorized by the judges of the pretrial division. In other words, there is no requirement for the Security Council to actively determine the existence of an act of aggression or to authorize ICC investigations for the court to proceed. This solution was possible because Article 15 bis created a consent-based regime and thereby reduced the scope of the ICC's jurisdiction. The Security Council's determination of an act of aggression in accordance with Article 39 of the UN Charter is not binding for the ICC. This follows from the due process guarantees provided under the Rome Statute, especially judicial independence, and it was explicitly confirmed in Article 15 bis and Article 15 ter. The ICC, therefore, fully retains its independence vis-à-vis the Security Council, as the court has to make its own assessment as to whether aggression has occurred. Nevertheless, we should recognize the ICC's especially limited room for maneuver in aggression cases. First, due to the political character for this crime, the Security Council has always been reluctant to qualify a state's act as aggression. It is more likely to determine the existence of any threat to the peace or breach of the peace rather than labeling an act to aggression. Secondly, the Security Council has also been reluctant with referrals to the ICC. It has only happened twice in the situation of Sudan and Libya over 21 years. And even if the Security Council referral takes place, the lack of follow-up and non-cooperation on the side of other state parties of the Rome Statute lead these Article 13 B procedures almost nowhere. And we should bear in mind, of course, the invisible rule. When the P5 states or their allies are involved in conflicts, let alone they started, the Security Council is paralyzed. Simply put, it will do nothing to bring perpetrators to justice. Then what's the point? If the chance of an aggression procedure before the ICC is so slim, why is it of historic significance to have this crime under the Rome Statute? From my point of view, the essence is development, that we have moved forward to a more just and peaceful world. Think about it, where modern international law started after the Second World War and where we are now. The system is not perfect, of course, but keeps becoming better and better. And if you don't mind, just as Professor Kovács, I am concluding my presentation with a quote from the late Ferenc, the last surviving Nuremberg prosecutor and enthusiastic advocate of the establishment of the International Criminal Court, who died at the age of 123 earlier this year. I'm often asked whether I am optimistic or pessimistic about the state of the world and what we can do about it. My answer is that I'm realistic. I see the problems very well about the International Criminal Court, for example. But I also see the progress. The progress has been fantastic. There has been a slow awakening of the human conscience. When I went to school, there was no such thing as human rights law, humanitarian law. There was no such thing as women holding key positions. When I see all of that, I know that we are moving in the right direction. So, never give up. Well, this brings me to the end of my presentation. Thank you for your enduring patience at this long conference day. And most importantly, bon appétit for the dinner and enjoy the rest of your stay in Budapest. Thank you.